Direct from the Golden Hill Broadcast Center, this is Talk of the Town on KNSJ with former San Diego City Attorney Mike Aguirre and attorney and former political science professor Douglas Holbrook.
This is Mike Aguirre.
And I'm Douglas Holbrook, and we're here again on Perspectives. Mike, sometimes decisions come out of the courts that have implications that, well, let me just jump into it. Are you familiar with the case out of the courts called Vergara versus California?
I'm familiar with a case involving a young lady by the name of Beatrice Vergara, and
a simple yes or no would have sufficed.
Brought by her mom as her guardian.
Well, without going into the details, do you think this case has the impact that I think it does? I think it's a case that follows in the line of Plessy versus Ferguson, Brown versus Board of Education, and I think this could be the next stage. On a broad level, would you tend to agree, or would you think it's just a minor little stepping stone?
Well, what this case deals with is a very important issue, and it opens up the door to what will probably be a whole bunch of litigation. So in the sense that in the law we call that seminal. It's a door opener, and it's going to take us into an area of the law that is going to examine the irrationality of how public unions and tenure are fundamentally in conflict with each other.
Good. I want to do what I'm seeing in this case is the labor unions protecting the teacher's right to tenure, or what they claim the right to tenure is, versus the children's right to equality of education. That's what I see. Am I miss?
No, I think you're taking too myopic an approach to it. You're too narrow. You're too narrow in your approach. Too narrow. Yes, I think you should look at it more broadly.
Okay.
And what this case really deals with is the fundamental inconsistency between public unions having the right to collectively bargain at the same time as they have tenure or they have civil service protection.
Oh, interesting.
And so what this decision does is it says that you have this irrationality with tenure of grade school teachers, where they are hired on a 2-year probationary period, and they have to be told well within those 2 years if they have tenure or not, whether they've made it. But at the same time, they're hired on a provisional basis to decide if they have the qualifications to teach.
Okay, as you were getting involved in the details of it, I missed the major point you were making, and it just hit me as you said that on one hand, the teachers and the teachers' unions are asserting the right to not be fired, and at the same time, they're demanding the right to bargain collectively.
Exactly.
And that's a very interesting point, and Mike, I missed that. Thank you for catching that.
And what they're basically saying is this: when you collectively bargain, you're saying, I want you to contract with me. Our relationship is based upon a voluntary contract under which we set the wages, hours, terms, and conditions of employment. But on the other hand, if I have tenure, then I have a right to work there no matter, irrespective of the contract. So and so what this case is dealing with is an added irrationality, where in California, if you send your student to an inner city school, there is a very high likelihood that there is. Let me rephrase it.
Well, I think I know where you're going.
The vast majority of incompetent teachers are shuttled into the inner city schools, and those teachers have 2 years to gain tenure, and they have 2 years to show that they have the credentials that they're competent to teach. But the problem is that the period for tenure, that is the time period that the school district can say, hey, we're going to deny you tenure, that expires as a practical matter before the time period needed to determine if the teacher is competent.
Well,
so you have this crazy...
I don't care what the time period is. I think what I'm hearing from you, and I love the idea, is that you're saying, hey, teachers unions, you got your choice, tenure or collective bargaining? Which do you want?
Well, this is the point. They want them both.
Of course. No,
and
I get
this is true with all public employees. This is true with the police.
I get it.
Okay, and this is where the real problem is, because what happens is that we've set up a system in which in which the government collects the money from the public employees, or the public employees, such as cities like San Diego, actually control the payroll system, and then they collect the money from the taxpayers. The money then is transferred into accounts at the union headquarters. Then that money is used to finance political campaigns. And then when their chosen representatives are elected, then the public employees sit down and have collective bargaining, while at the same time they cannot be fired. And so what's happened is you've created almost like what you used to think about with the Communist Party, a special group of public officials, public employees, those people that are within the umbrella of public employment, using the power of their positions to extract pensions that are based on actuarially unsound principles, pay that's always going up. And then you hear people talk about how poorly people are paid, but in relatively, I mean, it's kind of a complicated argument.
Well, I mean, I think you're seeing this in the context of when Reagan took on the air traffic controllers, public employees who could not be fired because of maybe civil service guidelines, and they're saying, well, we want those civil service protections, but we also want the right to collective bargaining. In other words, if the government gives you, it sort of protects you, you don't also get to take the position that private employees from private companies have to take, where they put their jobs at risk. The public employees aren't at risk, and therefore they shouldn't have that right.
But there's an added complexity. This is
getting more complex.
Right.
When I read the decision, I didn't see all these things in there.
The added complexity is this, that when we compare the public employee to the private employee, what we're seeing is that the private employee is being undercompensated, generally speaking, with the de minimis minimum wages that are paid, with the amount of concentrated wealth, with the fact that executives at the big companies are making 3 and 4 and 500 times more than the average employee. So, in a sense, the average employee, the average taxpayer, is getting hit from two directions. From their own employer, they're being denied collective bargaining. From their own employer, they're being denied decent wages and pensions. They're having to deal with the fact that so many jobs are being shipped off shore.
Okay, I have to ask you: are you getting this out of the Vergara case, or is this coming out of the Micah Gary playbook?
Well, I think that what we're trying to do is not. We don't want to isolate and discuss this outside the larger context. And the larger context is this: private employees are way behind on their income, and they're way behind on the amounts of money they have to pay for the essentials.
Okay, but here's the problem. The backers of this case, the specific individual out of Silicon Valley who funded this case on behalf of 9 students, very specifically said, look, I'm not here attacking tenure. He said, I'm not here attacking the labor unions. I'm here protecting the students' right to equal education. So the kind of things you're talking about are very relevant, and I do want to address them, but I don't think that was part of the decision. Now, if you're saying I want to talk about, where this case could go and the broader implications, fine, I'm on board.
Well, that's what I'm saying too is that in order to have a real understanding of what this case means, we have to look at it in its full context.
Okay.
And what I'm saying too is this: an average family that isn't a public employee and is not an executive in a big corporation the average family is not making what they should be making as income. Their wages have gone down, relatively speaking, for the last 40 years.
Proportionally, yeah.
Okay.
By the way, if you're just joining us, I'm Douglas Holbrook.
And this is Mike Aguirre.
And what prompted this discussion is a case out of California called Vergara versus California, in which Judge Rolf True basically put at odds, it was a case obviously brought on behalf of 9 students out of the LA Unified School District, whose argument was that incompetent teachers disproportionately affect the quality of our education. And so they argued that, if the schools in the minority districts are getting the poor, incompetent teachers, they aren't getting an appropriate education. Now, it was opposed by the labor unions, who focused on the issue of, and this is really all
by
about
the public unions.
by the public
employee
employee
unions.
unions, who basically said that their tenure laws are in effect for a particular reason, and it's to protect the free, so that a teacher can't be fired for saying something. But tenure has been used, I think, far beyond that, just to protect what this court is saying. It's protecting incompetent teachers, not protecting free speech.
Okay, so but see, what I'm trying to do here is let's put ourselves in the shoes of an average family, someone that's listening to this that's trying to understand what does this mean to them.
Yeah, I like going
Okay,
there.
all right. So what this means to them is this: they themselves, an average family, is not getting well compensated. They don't have the income, and they don't necessarily have the money to send their kids to a private school, or to move into a different neighborhood. So they're living in the inner city, sending their kids to an inner city school. Now, what they're now discovering and what they realize is, wait a second, not only do I not have the money to go someplace else, but the teachers that are at these inner city schools, there's a disproportionate number of them who are not competent, but they have tenure. So there's nothing I can do to get a quality education for my child, to get my child in a different track than we're at, our family's at, so that they can enjoy better financial income down the road. And so what this case does is it comes in and says, look, in the inner city schools, this anomaly where you have these 2 different statutes that are, or 5 different statutes, but affecting the students in a fundamental way, you or teachers in a fundamental way. It says, look, we have a process where a teacher can be tenured in 2 years, and unless you notify that teacher well before those 2 years are up, that teacher is tenured, and he cannot be fired. At the same time, we have a law that says the school district has 2 years to decide if the teacher should be credentialed, and that is, the teacher is competent.
And I'm going to suggest that's a very small part of it. And I'm going to, if it's a 15-page decision, I wouldn't read the whole decision, but I would cite, I think, what the essence of it, in which, point 1, what the judge says is the plaintiffs have proven by a preponderance of the evidence that the challenged statutes impose a real and appreciable impact on students' fundamental right to the equality of education, and that they impose a disproportionate burden on poor and minority students. Therefore, the challenged statutes will be examined with strict scrutiny, and the state defendants, the interveners, must bear the burden of establishing not only that the state has a compelling interest which justifies the challenge statutes, but that the distinctions drawn by the laws are necessary to further their purpose. And they're citing actually Serrano versus Priest,
right,
from 1971. And then they go on and say the state failed to meet this rigorous, strict scrutiny
But what
burden.
the statutes say is what I'm saying. The statutes say that you have 2 years to give a credential to say that the teacher's competent. You have 2 years to say the teacher's tenured, and there's an inconsistency between those two. That the way that but the point is, you're right though. The larger issue that this illustrates is not only are people that cannot get a decent salary, get a decent wage, are not only are they living in that injustice, but then when they send their kids to school, their kids are even having more of an injustice because they don't have the same access to quality teachers as students living in a different part of the city.
And that's a nice parallel. I'm suggesting that what this case is dealing with is not the front-end problem of a teacher who might not yet have their credential and somehow gets hired and tenured before they get that credential. But my suggestion is they're dealing with the back-end problem.
No, that's not what. I mean, the decision.
You and I are reading it differently.
Okay,
but that's okay.
Okay,
that's
well,
okay.
look. If you look at the decision, because it's important that we understand the reason that this case is being allowed to move forward, because the basic idea that you live in the inner city, you have worse teachers than the teachers that live in a different part. That's just been, that's an unfortunate part of life. What this is, the brilliance of this case, is they've actually been able to find a very well organized argument, or to develop a very well organized argument about the irrationality of how the statutes work. And by finding that the statutes are irrational in the way that they work, they got rid of the statutes altogether, which means they got rid of tenure altogether.
Yes.
And that's so in other words, sometimes what happens is you find that there's something specifically wrong with the statute, you get rid of it, but it has a much bigger impact than just curing that situation. And that's what you're talking about here. The bigger issue here is that the people that are in the public unions they've now been cast, and they've cast themselves to actually be in favor of a system that the judge says results in a disproportionate number of poor people or incompetent teachers in inner cities. And this is something that I have been arguing for from the time that I was elected city attorney. This is an argument that I came to in my own mind. I was shocked. I was Cesar Chavez's lawyer. And when I became city attorney, I was shocked, just like the judge is shocked. I was shocked to find out that the public unions actually are working against the welfare of the everyday inner city resident. Because what they're doing is they're using the power that they have to service those inner city students, inner city residents with libraries and rec centers. They're using their power to take the money away to pay themselves these exorbitant pensions that should be going to these inner city services. And so this education is just another example, another service where the public employees are using their power to deprive the people that they are aligned with, the people that they should be helping, as opposed to what they're actually doing.
What I think I'm hearing is the reason I'm not seeing this in the case and you are is because you've got much more background and you've dealt with this issue from the time you first came on as city attorney, and you've seen the evidence, anecdotal and
but your
and
point was made. You made the same point. You said, "Oh my gosh, I can see there is an inconsistency between saying, oh, give me a contract. Oh, I have tenure."
Right.
That you see that, and that's what the point is. But see, here's what the problem is.
And that was you're bringing your own background, and thank you for doing that. I was just saying this case doesn't necessarily deal with it, but what you're saying is it will. This case doesn't. Another
it opens
case
up.
will.
What it does, it exemplifies it. But the point also, though, Douglas, is that we want to go into, is that what is happening is that the people that should be working for the poor are working against the poor.
Okay. Yeah,
and that is a very discouraging, for poor people. But again, taking it the next.
I mean, you just put us back on the same page.
Right.
And
Okay.
I'm in agreement with
Okay.
you. Oh, by the way, for those who are just joining us, I'm Douglas Holbrook.
And this is Mike Aguirre.
And we're talking about, at least we started out focusing on the Vergara versus California decision, in which Judge Rolf True handed down a decision that put labor unions or public employee labor unions at odds, with their notion of tenure against the students' right to an equal education. And Mike, of course, because of his background when he was city attorney and his representation of Cesar Chavez, is pointing out some of the other implications that at first I thought, well, that's not in the decision, but you're bringing in the broader context, and that's important.
The public employees unions are playing into the hands of the conservative elements.
Okay. Yeah.
This is exactly the mistake, because we're not cleaning up our own house. The reactionary elements within our society are taking full advantage. In San Diego, for example, and other cities, there was a very unfortunate law passed that said that public employees get 401ks. That's it. That there's 1,000 reasons why that doesn't work. For 75 years, San Diego had a public pension system in which you got 50% of your last year's salary. That worked, and it worked year in and year out, and there were no risks taken in the investments. That, because of the greed and the ill-advised moves of public unions, what they did is they ruined it for everybody else that isn't already in the system, because they want more in retirement than when they were actually working. And the actuarial unsoundness of the system was recognized by the public, and the public's response was to embrace the reactionary reform put up by Carl DeMaio and Mayor Sanders and others, which basically punishes the next generation. So the next generation is going to be paying for the current generation's exorbitant pensions, but then they're going to be getting minimal or inadequate pensions for their own people. So they're going to have a double impact.
And that's interesting, because one of the comments that was made by the public employee unions after this decision came down was that, well, the real problem is not tenure, the real problem is inadequate funding. But what you're saying is, yeah, that's a problem also, and you're causing it.
Well, the reason is because taxpayers are not going to fully fund anything if they think the public employees control the treasury once the tax dollars are collected, and are going to continue to divert it to the selfish agenda of the public employee unions, as opposed to and Douglas, let me just say this: we have police that don't provide the police services that should be provided. We have firefighters who don't put out and don't provide the fire protection that we need. We have libraries and rec center workers who are not at those libraries and rec centers the hours that they're needed. We have people that take care of the streets and the sidewalks who are not taking care of the streets and the sidewalks. We have teachers, many of whom are good, but there are a bunch of them who are not good, who should be better, but they're able to avoid that.
Or who might have been better at an earlier time, but have become incompetent.
I think that the big problem in the inner city schools is that whether it's the kids, the young people that are just coming in, have not cut the mustard, are not prepared to really help educate and get the inner city students where they need to go. Well, but my point is the taxpayers are not going to pay taxes if they don't get a return on their money. They're not going to pay taxes just to enrich a small group of public employees who have rigged the system. And the problem with that is that one of the few ways that we have to counter the disproportionate wealth of our society as it is today is through public unions, is through public service. That is the one way that people can have some financial security working as public employees, that so that you don't have and you can provide an alternative to the system we have now, which is a members only system. If you have parks, if you have rec centers, if you have public services that you can enjoy that don't cost anything, that are free, then you don't need you can offset the disadvantage, the financial disadvantages. So the average person is getting hit from two directions. They can't get their kids into schools where they're going to get quality educations. They can't get their kids to rec centers or libraries where their hours are open. And the roads and streets are not paved. They are not getting the basic protection from the police when their houses are burglarized. But on the other hand, when they get their mail, they get excessive rents. They get excessive rates from the Public Utilities Commission. The prices for the food, everything else is going up. So they're getting hit from every single direction. And what this basic case is, congratulations to the judge.
Oh my gosh, yes.
Congratulations to the judge.
By the way, while we're congratulating, I'm Douglas Holbrook.
And this is Mike Aguirre.
And on Perspectives today, we're covering the Vergara versus California decision. And as we head into the end of the show, yeah, go ahead and congratulate him. That's nice.
And I think what this judge is basically saying is that we don't want. Well, there's two things. One is, look at whose side the public employee unions are on. They're on the side of the argument that it's okay to have incompetence. It's okay to have disproportionate incompetence. They're not really even making the argument that it's not true.
Yeah, I mean, aren't the judge is certainly commenting on tenure itself, and he's saying tenure is a concept that was there to protect the teachers so that they didn't get fired for saying something that should be protected under the First Amendment. But what's happened with tenure is it's not protecting First Amendment rights. What it's doing is it's perhaps promoting laziness. That once they get hired and they get tenure, it's like, well, I can't be fired. Why do I really need to, stay competent? That's where I think
Douglas,
it's going.
I couldn't agree with you more. Tenure is needed so that teachers can be free to properly teach without regard, so they can seek the truth. But let's take it the next step. Let's look at who has tenure. Politicians who never take positions on issues and are reelected and then just run for every single office there is, and they don't offend the concentrated wealth crowd, they have tenure, a different kind of tenure, but they are elected repetitively to public office. Federal judges have tenure. Okay, you have corporate executives who in perpetuity elect boards of directors. They have tenure. Lots and lots of people want a certain type of tenure that basically says, not for the good reason that you just cited, or not even for the good reason that federal district court federal judges theoretically have tenure, but people want tenure or seek tenure so that they can remain comfortable, so that they can remain, and they're willing to pay the price of not doing what needs to be done in order to move our society forward. And what this case is saying is those teachers who are not prepared to prepare or to get themselves competent can no longer rely on the shield of tenure. They are going to be gone. And I think that is a positive thing, because what it can be, but here's what's going to happen. This decision could result in a lot of reactionary people exploiting it. And this is another reason why those of us who are on the slightly left of center spectrum need to clean up our own house. The reformers need to reform the reformers, or what will happen is cases like this will come along and the reactionary forces will come in, and they're not really interested in inner city education, but they will come in and they will deprive the inner city communities of even it'll even be worse.
Obviously, it was happening, and because of one individual, if you want to applaud somebody, I do applaud the judge, but you have one individual up in the Silicon Valley, and you could Google and figure out who was behind it, but one individual funded these lawsuits for these 9 students, and basically, just like in the movie Network, sort of stood at the window and said, you know what, I'm mad as hell. I'm not going to take it anymore. Right. And that's the kind of thing we want to applaud. That's the kind of thing we want to see happening. That's the reason for this show. That's the reason for Perspectives. We want people to look at things going wrong, of which this is just one example, and say, I'm mad as hell, and we're not going to take it anymore. And this is a case, in my mind, that follows in that pattern of a group of students in Topeka, Kansas, which were the basis for the Brown versus Board of Education. I see this case in that same context. Do you? I mean,
I do.
We've only got about 30 seconds left. Tyranny,
whether it is exercised by Southern racists or racists
or
as
out
a whole,
out on the West Coast more subtly,
or tyranny exercised by selfish public union leaders, I don't see any real difference there.
And I would agree. And I think we're going to conclude on that agreement. I'm Douglas Holbrook.
And this is Mike Aguirre.
And we've used the Vergara versus California case to focus on some of the inequities and some of the places that equal opportunity is not really being provided. It's been given lip service, but we don't really walk the walk. Again, I'm Douglas Holbrook.
And this is Mike Aguirre.
And we're getting closer to our dreams. Thanks for being with us.
Thank you for joining us on Talk of the Town with former San Diego City Attorney Mike Aguirre and attorney and former political science professor Douglas Holbrook here on KNSJ Descanso 89.1 FM, serving San Diego.